numbers 4 and 5.
Courts and Criminal Matters Bill, Committee Stage. Weathertight Homes Resolution Services Financial Assistance Package Amendment Bill, Committee Stage.
I declare the House in committee for consideration of the Courts and Criminal Matters Bill and the Weathertight Homes Resolution Service Financial Assistance Package Amendment Bill.
Mr. Speaker.
Mr. Chairman.
The House and Committee on the Courts and Criminal Matters Bill and the Weathertight Homes Resolution Services Financial Assistance Package Amendment Bill. Members, we move first to the Courts and Criminal Matters Bill, and the question is that Part 1 stands part. Lynn Pillay.
Thank you very much, Mr. Chair. It's a pleasure to take a call on this bill. We in Labor do support this bill, but we do it with some concerns. Obviously, it's been described by the government as the most comprehensive set of measures to strengthen the recovery of unpaid money in 12 years. We don't think it goes anywhere near that far. And in terms, I think, is an indication of how this government is. But in terms of totally out of touch. But the reason we in Labor support this bill, Mr. Chair, is quite frankly because it results from the work that was started and went some way whilst Labor was in government. The figures released earlier this year showed that between July 2008 and June 2009, the courts actually wiped 95 million of the total 806 million in unpaid fines. Now, those unpaid fines are increasing every year, and that, of course, is a loss of revenue, but also it is actually not ensuring that accountability, that fines aren't paid. And that is very much a key focus of this bill. We question why it's taken so long to come to the House. It was ready, and in fact there are many bills that I would rather have seen go through this House, certainly, than taken a back step, actually. Many bills, Mr. Chair, to this one, which actually does go some way to doing some good, as opposed to a number of other bills that this government has brought in that do nothing but that cause harm, immense harm in some cases. If we look at around employment relations, some of the law and order bills. But going back to this bill, Mr. Speaker, because I know you want me to, Mr. Chair, I know you want me to do that. This bill does it does actually omit some proposals that were developed by Labor. For instance, one proposal that we had was to create a single agency for the collection, or to have responsibility for the collection of those fines, and that at the moment there are 80 plus issuing authorities, and this is cumbersome, very cumbersome, and impedes the speedy collection of fines. So it would have been very, very helpful, Mr. Chair, if that had been taken. There had been more work done. I hesitate to say, but I think perhaps it was a little lazy to not put the effort into ensuring that there was a single agency. That would have been certainly a more effective way of collecting fines. The Minister Georgina Tuhuhu wanted to introduce a SOP, an order paper at the committee stage to allow offenders convicted of 3 strikes offence but not warned of the consequences to further offending to be brought back to the court to have that warning issued at a later date. And that was something that we did not support. Perhaps that SOP could have been avoided if the Minister of Justice, rather than the police, had been lead advisors on the Sentencing and Parole Reform Act in the very first place. But as we said, the bill makes amendments to the District Courts Act of 1947 in terms of attachment orders. And those orders are used to allow deductions to be made from wages and benefits to pay debt. And certainly when we look at penalties that accrue over time, the sooner people can be put in a position, whether it's by an attachment order, in making payments of those debts, then the better it is actually not only for the country, but also for those people. Also, Mr. Chair, deputy bailiffs, there was some discussion around that, Mr. Chair, to clarify that a person who is appointed as a deputy bailiff may exercise, Mr. Chair, if I can continue, thank you, Mr. Chair, the powers and perform the functions and duties of a bailiff in respect of any district court and not just in relation to a particular district court. That in terms of employees being subject to attachment orders, going back to attachment orders, carrying over the existing law, that it is an offence for an employer to dismiss an employee or alter the position of an employee to the employee's prejudice because, among other things, an attachment order in respect to the employee has been served on the employer. However, the new provision removes the existing onus on the employer to prove that the employer's actions were not taken as a result of the employee's debt or of the attached order. There's some changes around contempt proceedings and also in terms of the driver's licensing stop orders, some amendments to the Land Transport Act of 1998. And that liable persons, in terms of driver licence stop orders, which are obviously a very effective deterrent, the new measure has the features that liable persons are sent a warning notice, and that warning notice is very important, giving them 14 days to resolve their traffic penalties before their licence is actually suspended. And then those driver's licence stop orders will actually suspend all driver licences held by the person in default, including limited licences, and also prevent people from obtaining a licence, including a limited licence, whilst that order is in place. And then following those orders in terms of the process, all driver's licences are suspended until the overdue traffic penalties are resolved through payment or a payment agreement which is negotiated and agreed, or until the penalty is substituted for an alternative sentence. Now, if that person drives in breach of a driver's licence stop order, which is a pretty stupid thing to do, Mr. Chair, if that does happen, then that vehicle will be impounded for 28 days. So these measures are stern but fair, I'd go to say. These measures go some way in terms of making the system certainly fair, but more importantly, more effective. More effective and stern but fair, as the former principal would say, and I think that that in terms of going forward in terms of this certainly does make some positive changes. Superior priority of seizing property. The District Court can obtain higher priority over secured property of a credit provider if the loan was advanced when the overdue penalties could have been released under the credit reporting proposal, and when that property is subsequently seized by the court, some or even all of those discoverable penalties are still overdue. So there's also changes around substituted sentences, where the bill actually authorises prison or home detention sentences to be substituted substituted for unaffordable and unenforceable payments. That, Mr Chair, is something that we wouldn't like to see, and we would hope that that is something that happens very rarely, and that the enforcement and payment of fines is more effective under these bills, because I think we would all agree that subjecting somebody for unpaid penalties and fines does not serve any purpose if they are sentenced to home or prison detention, and that a far more effective way is to obtain those monies and obtain those penalties either through payments or through a payment agreement.
It's time for the dinner adjournment. I shall resume the chair at 7:30.